And I remember sitting in the kitchen with my dad when I was filling up my ACA forms in those days, when you're choosing universities. And I was saying, Dad, can I put English first choice? And he said, do me this one favor, put law as your first choice, and I promise you, if you don't like it, you can switch to English.
Welcome to our new series, ADR Corner, AIAC On Air. This series is designed to spotlight the inspiring journey of senior arbitration experts and give our audience an intimate glimpse into their careers. For our first episode, we have a very special guest with us, Ms. Shanti Mogan from Shearn, Delamore & Co. Welcome to our series, Ms. Shanti.
Thank you, Vishnu. Please call me Shanti.
Yes. So if we could begin right at, so what we would usually do is we would have a long introduction that we would read out, but I don't want to do that. In fact, if I could ask you, how would you introduce yourself to our audience?
Okay, I'll do that. Thank you, Vishnu. Vishnu has told me that this is supposed to be very conversational. And I note he said it's also supposed to be inspiring, so I aim to please. I'm Shanti Mogan. I'm from Shearn, Delamore. I've been there for the better part of my life, 35 years. I think the best 35 years in my life. I love litigating, arbitrating, public speaking. What I don't like is vodcasts with a camera right on me, so I'll do the best I can.
Thank you so much. So if I could ask you, why did you choose law, and what really inspired you to take this career path?
Okay, that's really easy because my dad was a lawyer, but oddly enough, I wanted to do English, and I wanted to do English literature. And I remember sitting in the kitchen with my dad when I was filling up my ACA forms in those days, when you're choosing universities. And I was saying, Dad, can I put English first choice? And he said, do me this one favor, put law as your first choice, and I promise you, if you don't like it, you can switch to English. Of course, we were naive those days, right? We believed our parents. I don't think I could have switched mid-course, overseas. But he said, law will give you a discipline and a logical mind, which will do you well in practice. So try it for me. So I did, and there was no turning back.
Now, the rest, as they say, is history.
It was, indeed.
So was there anything early on in your career that reinforced your decision to continue in this career?
Yes, in fact, I think there was, because in my first year, we had our lectures, and it was public law. My personal tutor was the lecturer, and I was thoroughly confused with the topic and with some legislative discussions that he was having. And I think he saw, I was one of those keen beans who sat right in front, so he saw me. And he said, you looked really confused. So I said, yes, I think this is really not for me, this subject, which was public international law. And at the end of that year, my public international law results were really bad. And I was really upset. And then he showed me some results. We all had compulsory moots. Right. Which we all participated in and which I prepared for so carefully and for a long time. And of course, I felt that, okay, it was all right, but, nothing to shout about. And then he showed me the moot results. And he said, you see, you have something to be quite proud of because my moot results were good. And I kept telling him I wanted to go to Singapore and be a lecturer. And he said at the end of the 3 years, when you look at your results, you do well for the practicing subjects like tort, contract, and maybe not so for the more academic ones like public international law. So he said, it seems like you're heading to practice. And well, as they say again, I came back to Malaysia and went to Shearn. And I'm very happy I did.
That's fantastic. It's not very often that you have someone who has been in an organization for that long. So it's actually very inspiring to hear that, because especially in this day and age, you have people who keep switching or jumping ship from time to time. But how has that experience been? And if you could elaborate on your time at Shearn?
Yes, definitely. Yes, it is. Nowadays, I'm very lucky when I have members of my team who stay on for more than 5 years. I think I've done well. So in my batch, I think we had 18, and now we are 3. But 3 of us have been there for 35 years, and that we still have seniors. So they've been there for longer. So there is something, I must say, that Shearn is doing right. Even though I do appreciate now that a lot of people move to smaller firms. The wonderful thing about Shearn from the outset, apart from my 2 then bosses, which you will hear a little about as they were my mentors, is that you are never lost. Any issue that arises, any claim that's made, any point of law that is thrown at you, somebody has done it. So there's always somebody to go and ask and bounce ideas off. So that was something I always found wonderful.
So I think that's really important. If I can share a small story with you. When I began my career in litigation in New Delhi, right out of law school, I joined the chambers of a junior in Delhi, Mr. Gautam Khazanchi. And the very first, so he sent me to court. There was a legal aid hearing that we were doing, and before the matter came up in court, we were required to go and see the client. So the client was someone who was in for a rather grievous offense. I wouldn't want to say it on this podcast, but we were undergoing a virtual hearing, and this is my very first experience with a client. And so me and another colleague of mine, we join in, and he immediately, on seeing us, he's like, I have been framed. I am going to, take a rope and hang myself. And this is my very first interaction. So I didn't know what to do. And but of course, my other senior was there, so he sort of handled matters. And I went back home and I wondered, what is this? What have I gotten myself into? But then, as time progressed and as we did more matters, I think it became easier, and I was reassured that this is a very fulfilling career. So in that respect, were there any role models that you had early on in your career? Anybody who shaped the way you thought, or the kind of practice that you were going to undertake at your firm?
I have to say definitely yes. I mean, my dad, I suppose, the first, because he was the one who inspired me to do law and to tell me that it would give me a logical way of thinking, and I feel, I'll try to be modest, I feel it has helped me think more clearly. But within the firm, of course, I had 2 bosses then, who then became my partners, Cecil Abraham and Robert Lazar. And each of them were quite instrumental, I would say, in forming my career. Robert Lazar was the kind of partner who would show you by how he handled his matters, how to strip what you would say is a complex problem. I would tell him, we've got this really big, difficult, complex dispute, and he'd roll his eyes to say, nothing is too big and difficult, you just have to break it down. And he'll break it down to something as banal as baking a cake, for example, to bring it to the simplest denomination for the court to understand. And I found that ability that he had stood him in good stead and helped me present a far simpler case in court and in arbitration than I would otherwise have. Cecil Abraham, of course, was instrumental. He was my primary partner and boss, and he was instrumental in pushing me to arbitration, and he was very generous in that regard. My first matter took me all the way to New York, and he told me to go and exposed me to arbitration in that fashion. He also was the one who encouraged me to do the Chartered Institute exams at an early stage, and really my earliest start to arbitration, I have to put front and center at his door. He was the one. Yeah.
Right. So I love reading books related to law, and also from people who have practiced in the past. So I was reading an autobiography by Miss Leela Seth, who was the first female Chief Justice of the Delhi High Court.
Right.
So she mentioned in her book some of the challenges that she faced, and I think one thing she brought out was that back when she began practice, there wasn't even a ladies' washroom in court. And the other thing was, when she was sitting in the library, there would be a lot of male colleagues who would come in and be like, "What are you doing over here?" Or so in that sense, did you face any challenges early on in your career? Something that
yeah, in terms of being
in
a
terms of
female
practice,
partner, sort of thing. It's really odd because when I did come, there was this big talk about Shanta Menon being the first female partner, and there was nobody before then. And a lot of the female lawyers probably had appeared to have less challenging portfolios, maybe debt collection portfolios. Male partners seemed to have more exciting, appeared, all this was appearances. Female lawyers appeared to become salaried partners, and male appeared to become equity. It all seemed like that when I came. But actually, when I started out, I would say that Shearn, maybe it was the newer generation, because when I came in, and then it was the time of the Cecil Abraham and the Robert Lazars, and it was the newer batch. I felt that they were quite blind to gender. And you've got to take the good with the bad. I remember that there were a couple of us female lawyers who got pregnant, and when you go to court, you're still carrying the big pilot case and the lots of documents, and your partner is walking in front and kind of probably oblivious that, you might be heavily pregnant. Mm-hmm. But the good part of it is they are equally blind to gender when it comes to giving the juicy pieces of work, when it came to partnership, acceleration, senior associate, moving into partnership. So I thought, it's okay, you take everything as long as we are all viewed as people, as opposed to male and female. It works well for me. And in Shearn, I think people would have heard the story that there were equal representation of male and female in the partnership, sometimes more female partners. So it was something in Shearn, and probably maybe more in Malaysia. I do find that internationally, at the early stages when I went for conferences, there was one conference where I was the only female in the room, and it was in Europe. None of the men were interested to talk to me. Of course, that has since changed.
Right.
I was quite young, so maybe it's a difference in different jurisdictions.
Right. No, but I see that trend slowly shifting in India as well. In fact, my own batch of law school, I think there were more females than males. Yes. So it seems to be an improving trend. We're going to have our very first female Chief Justice of India, Ms. Justice Rangaratna. So I think we are definitely heading in the right direction.
Yes, I mean, you look at Malaysia, right? You've got so many female in top levels.
In fact, Director of the AIAC is female, Ms. Dr. Mary. We have our CEO, Dr. Carmelina.
That's right.
So the tide definitely seems to be shifting in the positive sense. And in fact, when we try and organize conferences or even these events, we try and keep a very balanced panel so that you have both males and females on there. Yes. So now having covered the early part of your career, if we can move on and talk about why you chose arbitration and how the experience has been.
Yes, we can. I think arbitration, I didn't come to Shearn and think I want to do arbitration. I came to Shearn to say I want to do commercial disputes. That was true. I didn't want to do criminal. I didn't want to do industrial. That was an offer. That I was quite clear. And I didn't want to do transactional work. So when the opportunity came and I was finishing my chambering, so obviously I seized on it. And then I think possibly because we had a media broadcasting client, which my then boss Cecil Abraham and I were servicing, had a big dispute. And so one day I was asked to come, and there were all these lawyers who came from New York, and we sat around this table and we were discussing this big dispute. And the next thing I knew, it was going to arbitration, and it was Malaysian law, but with US rules of federal discovery. So the lead was going to be US counsel, and the Malaysian counsel was going to be the counsel for Malaysian law. And Cecil Abraham was quite senior, so obviously he wasn't going to go there and play second fiddle to US counsel, right? Because he'd do his own case. So I went. So I was the sole Malaysian rep. So it was lovely because then I got the chance to speak on the Malaysian law issues and to do the briefs on the Malaysian law issues right there and be present during that was probably my first big major arbitration. And then it was in New York, so that made it even more special. And then it was US counsel who do things so differently. So it was an eye opener as to how people do things. I mean, they had federal rules of discovery, which meant that I spent hours in the Malaysian company going through discovery, which is non-existent now in arbitration. Right now, we just do very limited disclosure. So it was just a different start to the whole game. The way they do their cross, the way they have a. It's very much about, are you telling the truth? Are you lying? And in Malaysia, it's breach of contract. You don't go into motive, but it's all very dramatic over there. So it's all quite exciting. And then I never looked back, and a lot of other matters then followed suit.
Right. In terms of personal preference, do you prefer being a counsel or an arbitrator if given a choice in a matter?
Yeah,
it's a
someone
very
asked
difficult
me this.
question.
It's not difficult, but I don't. Let's put it this way. I like being an arbitrator, and I like having a couple of arbitrations a year as arbitrator. But I'm not ready to give up being counsel because there's nothing quite as sweet as going to court or arbitration and advancing your position. And when the tribunal or the court is with you and you're in synergy, there's nothing quite like that high. And so I'm not ready to give it up.
There's also a very interesting part of litigation that takes place after the arbitration award is delivered. So you go to court, try to either set aside the award or enforce it. And that requires a very different skill set as well. So there's a lot more that you can do as counsel.
Yes.
But if I could ask you, how did you manage to get your first arbitrator appointment, and how that came about? And if you have any tips to share with our younger crowd on young lawyers looking for their first appointment?
You know, I think if memory served me correctly, I probably got my first arbitral appointment from AIAC, and it was probably during the time, I can't remember the lady's name. She was the director. She used to be in court. So she was like a registrar and then became probably a judge, and then she became arbitrator. It was years and years ago. And one day I had gone with my husband and possibly, I don't know whether my son was born or not, and we'd gone to Phuket, and then I turned on my phone and I had got an arbitral appointment. It was small, but it was so exciting. So I never forgot it, and it was a domestic arbitration. And so that's how I started doing arbitration as arbitrator. Before that, I was doing it as counsel. And what tips do you have about getting appointments? That's always hard. Yes, of course, you have to put yourself out there, you know. That's not my cup of tea. I'm glad that I'm older. But yes, you have to do the networking. You have to know people. People have to remember you and see you. You have to have a great CV. You have to put that CV out there. But in terms of how to be a good arbitrator, that I can assist with, because that's more tangible, right? It's not so much of BD. BD is not really my thing. And it's a different skill set, and it's quite exciting. And the first time I learned that I don't jump in, you know, when they're cross-examining, I don't jump in to say, ask this question. I have to hold back, because we all have a different way.
Instincts kick in.
Yes, you have different way, you know, there are many ways to skin a cat. So I'm thinking, why is he not asking this? Why is he not doing that? Or why is he doing that, you know? And I have to remind myself to hold back and let it flow, and don't think that I must take control. I must let it flow, and then from there make my decision. And the second thing, of course, is to make that decision. As counsel, of course, you're always advocating a position. It's much easier than having to balance both and coming up with a cogent award. And what I do love is when you do awards for all these different institutions, you have such different insights. Each institute comes back, right? Quite a few institutions do scrutiny. And so they give you their feedback. And it's
Right.
always exciting because however young or old you are, there would be something that someone raises which piques your interest. So I always like that. So you can better your award or take into account or tie up loose ends. Yeah, it helps with that.
Yes, that's very interesting, because from an institutional perspective, when we undertake the technical review, there's a lot of things that we also try and look at, and it's always we kind of you have to be wary. You can't overstep.
Yes.
You're only giving suggestions to the arbitrator, but then there are other institutions which could even dictate what you can write in your award. So that's all dependent on the kind of rules that the institution has.
That's right.
Is there an element of fear when you're writing an award? Do you think, or what do you think a judge sitting in a court might do with my award? Is there any such element that ever kicks in when you're writing?
Oddly not. I don't know why. There's always a fear when my matter in court goes on appeal. I think because that I have a client.
Right.
I have a client with an interest and I want to make sure my client is happy. So every time I go to court for a client, it's not fear, it's obviously not fear, but it is you want to make sure that you secure something positive for the client. With an arbitration, I always find that it's easier because I'm in control. So I have to do what I think is right by the parties. And then I've come to the stage, I think, in my life, if it's set aside and I feel that I have done right by the parties, such is life. Whereas in court, you can have done what is right by the parties and done your best, but the tribunal might not be with you. And another tribunal might, and then you feel, you just feel that, your client wouldn't have had a good day. So I think it's more in court or in arbitration, but not sitting as arbitrator. Once I've done that award, I think I'm always happy. I won't let it go out until I'm like, I'm happy with it.
Cross the T's and dotted the I's.
Yes, definitely.
Right. So in that terms, you happen to be on the SEAK Court of Arbitration.
Yes.
You're one of the members of the SEAK Court of Arbitration. As you know, the AIAC is going to introduce its own Court of Arbitration. So do you have any thoughts and what you think and how it can sort of help the center to go to that next level?
Yes, I think it's a very good idea, the court, because in the past we've had so many instances where either here at AIC we didn't have a director, or during COVID you couldn't do an appointment. Everything was stopped either because there was a vacancy or because, I don't know, the director's in Kuwait or something, or if the director's away. It just seems like that's not the way to practice. Whereas with a court, you have two things I found out from the court. We go for court meetings where many of the court members come. And during those times, we get the opportunity maybe to comment on changes to rules or changes to whatever is being implemented by by SEAK court. And you get to hear everybody's point of view and its nationalities globally. So it's amazing because you think of something, somebody else thinks of something, you do a bit of brainstorming, and then you put it all together, and then it sees fruition. And SEAK is excellent because then they will share what's been done, and you remember which committee you were in where you all discussed the issue and presented it. So you feel it's live, and it has the views of so many different parties from different jurisdictions. And then they have this other thing when you have, like in Malaysia, if you have a challenge before the AIAC, generally I understand that the director will make the decision. Obviously, he or she would have their people behind the scenes, but this one you get people on the court. So there's been jurisdictional challenges, there's been disqualification challenges, there's been consolidation, joinder, all of this, they will constitute a committee of 3, and you're England, Australia. Why wouldn't you like it? You're sitting with a former judge, or you're sitting with somebody from Korea that you've never experienced their viewpoint, and you discuss and come to a conclusion on how that gets approached. it must be better than one person deciding. So I think that way I felt, wow, this is clever, because apart from the fact there's obviously autonomy and independence, you also raise, one would hope, the quality and the level of the decision, because it's got input
Not just one person.
It's not one person, and it's not just anybody, it's people that the court has felt were worthy to sit on the court. So they obviously won't be, any fly-by-night. So it'll be great. I think it will do very well, and hope it's going to happen soon.
Right. So we've spoken quite a lot about your career, your early life, but then aside from law, once you're done with office and when you go back, what is it that you do to recharge, or do you have any interests other
yes,
than
definitely.
hobbies that you'd like
My
to share?
passion is tennis.
Right.
I love tennis. So,
Okay.
when I got to a certain stage in life, I thought I was going to pick up. I was doing something else, and then it was a hobby that, I was worried. I used to do horse riding. I wasn't great, so sometimes I'd fall off the horse. So I made a decision. What is going to be that thing that I do after hours? Because you need something, right? And so I started tennis, and it's been great. So it gives me that release every time on a Friday after a hard week that you go play tennis. You feel like you can release the stress. So that's been lovely.
And if I can ask you, who's your favorite player?
Oh, Nadal, of course, who's now done.
Who's now
yes.
retired, yes.
Yes, so it has to be, what's his newbie from Spain? Alcaraz.
Alcaraz, yeah.
Yes.
He's a pretty
Yeah.
good player as
Yeah.
well. Right, so just to end our conversation now, if we have a lot of young lawyers who are watching this episode,
Yes.
We also have the AIAC's Young Practitioners group, so we hope that a lot of members from that group is also watching this episode. What is the advice that you would like to give to the young professionals who are looking to build a career in international arbitration?
Yes. While I look back on my life, and I would say I don't have any real regrets, I was a very timid, nobody believes me when I tell them, I was very timid and shy in my younger life. So right from university, I would not be the one who volunteers to answer. And in Shearn, in my younger days, partners would then, there was a huge gulf between a partner and a young lawyer. So they would probably ignore you in the morning and not say hello. So you would sidestep them. So you don't speak to them. And so when your views are sought, apart from, of course, when the client asks you, I tended to be more reticent for a couple of years. And then I can't remember who someone said in Shearn, in a place like Shearn, if you don't speak up and you don't, make yourself heard, then you will be lost. And I switched, and that was a huge difference, because then after that I realized that, it's not everything that everyone says that's a top dollar piece of opinion. It's everyone has views. And once you stop worrying about what somebody is going to think about what you say, then you can just start saying what you feel and doing what you feel and making your presence felt. So I felt that first 5 years, I could have done things differently and been much more in the game than been quiet. What I now tell all my younger lawyers, which I feel is so important, is not to let the narrative control you. So what we have now in practice, both in arbitration and in court, is people throwing everything but the kitchen sink at you in trying to confuse the dispute. And courts and arbitrators, as time goes by, people are shorter with their time span. So you got to, I think Tan Sri James Fong told me once, you got to take your best point first, because after that, there'll be a bit of switching off as to, so you take your big compelling point first, and if you make it, then you've got them. So you don't go through the whole, boring side story. You take the main point. And so what I notice my young team tends to do is that they respond to everything that is thrown at them. But half of those things are not even relevant to determine the dispute. And when you do that, you go off on a tangent, and then you come back to the issue because you want to tell the other side what you're saying is wrong. But after you spend half the time doing that, you've already lost your tribunal. So I would say you control the narrative. Don't let the narrative control you. And I feel you follow the facts, and you will always come to the right result. So stick to the facts. A lot of young lawyers like to put in a whole lot of law because you can just put it all in, but if you don't know the facts, you won't reach the right conclusion. So I feel that's helped me so much in practice, in my cross, in my award writing, in everything, to be diligent with the facts. And then the facts will present that clean issue of law that you may need to answer. But without the facts, you won't get there. Yeah, so I thought that's quite useful because I found it useful for myself, so I always tell that to my team.
I think that's some great advice, and our audience is pretty lucky. I don't know if you remember, Shanti, the first time that I met you was during the arbitration workshop that we had for the amendments to the Arbitration Act.
Yes, of course.
And me and my colleague were giving a presentation on the amendments. And we had a harrowing morning because there were a lot of questions
yes, I remember
that were put at us. But something that always stuck with me is that after everything got over, you were the only one who came to the two of us and said, good job and well done. And that was so reassuring and encouraging for us. And I think that speaks a lot about your character. So thank you so much for joining us. It's been an absolute pleasure speaking to you and conversing with you.
Thank you. And I wanted to say I did that because I was so impressed. I really was genuinely impressed with you two young people, and there were all these senior lawyers, and you had to answer, and you all did it amazingly. So I thought, you know, these days I remember to tell people when I think something positive, because then it might help you moving forward. So it was from the heart. Thank you.
Thank you so much. And thank you for joining us. I thoroughly enjoyed our conversation.
Thank you.